A father, a son, a mobile phone shop, 15 minutes past curfew. Within 4 days, both were dead. And the men who killed them wore badges. This is Constitution Compass. Real cases, real sections, real punishment across 10 countries. Today's case will make you question what justice actually means. Let's begin. It was Friday, June 19th, 2020. Thoothukudi district, Tamil Nadu. India was under COVID lockdown. Shops had curfews. Lives hung by very thin threads. P. Jayaraj, 59 years old, ran a woodworks business in Sathankulam. His son J. Bennix, 31, sold mobile phones nearby. Two ordinary men, one family, one quiet evening. That evening changed everything. At 7:30 p.m., police arrested Jayaraj. The alleged offense? Shop opened 15 minutes past curfew. When Bennix heard, he came to the station. He was pulled inside too. What followed was not legal detention. It was a coordinated assault. From 7:45 p.m. to 3 a.m., both men were beaten in rounds. Clothes removed. Walls tested positive for their blood. A doctor issued a fitness certificate despite profuse rectal bleeding. The magistrate remanded them without examining their bodies. By June 22nd, Bennix was dead. Internal bleeding. By 23rd June, Jayaraj was gone too. Punctured lung. India's George Floyd moment had arrived. The case that followed, the Sathankulam Custodial death case, took 6 years and ended with something that shocked even the legal world. The CBI filed its charge sheet on September 26, 2020. 9 IPC sections, each one targeting a different dimension of what happened inside that station. Section 302, murder, intentional killing, maximum death penalty. Applied because both men died from injuries inflicted inside that station, directly, deliberately. Section 120B, criminal conspiracy. The officers planned and coordinated. Multiple minds, one shared intent. All equally liable under law. Section 342. Wrongful confinement. Jayaraj and Bennix were held with no lawful basis. Their detention was illegal from the start. Section 201. Causing disappearance of evidence. The police attempted to erase what happened inside that room. Section 218. Public servant framing incorrect records. The medical fitness certificate, signed despite visible serious injury, was a lie on paper. Sections 182, 193 and 211. False information, false evidence, false accusation. And Section 34. Common intention, binding all 9 together as one legal unit. And this single set of sections changed everything that followed.
10 officers were originally arrested. Sub-Inspector Palthurai, the 10th, died of COVID-19 during investigation. 9 faced trial. On March 23, 2026, all 9 were convicted. On 6 April 2026, all 9 were sentenced to death. Inspector S. Sridhar, Station House Officer A1, IPC 302-120B, 342-34, sentenced to death, ordered to pay 24 lakh rupees compensation. Sub-Inspector K. Balakrishnan arrested Jayaraj, initiated the first round of beatings, IPC 302-120B, 342-34, sentenced to death. Sub-Inspector P. Raghu Ganesh arrived after 11:30 p.m. and escalated the violence, IPC 302-120B, 342-34, sentenced to death, ordered to pay 16.30 lakh rupees. Head Constable S. Murugan participated in successive rounds of assault, IPC 302-120B 34, sentenced to death. Head Constable A. Samidurai, present throughout the ordeal, active participant, IPC 302-120B 34, sentenced to death. Constable M. Muthuraja, present from the first round, IPC 302-34, sentenced to death. Constable S. Cheladurai participated in beatings alongside other constables, IPC 302-34, sentenced to death. Constable X. Thomas Francis, part of the group assault across multiple rounds, IPC 302-34, sentenced to death. Constable S. Velumuthu, convicted for role in the coordinated assault, IPC 302-34, sentenced to death. The court ordered collective compensation of 1.40 crore rupees to the family of the deceased. Judge G. Muthukumaran said these were men who had the law and destroyed it. He then broke the nib of his pen after signing the judgment. This case exposed one critical gap. India has no standalone law against custodial torture. The Prevention of Torture Bill, drafted in 2010, was never passed. The 2023 Bharatiya Nagarik Suraksha Sanhita replaced the CRPC but carried no dedicated torture provision. Custodial deaths remain prosecuted under ordinary murder law. A fresh Prevention of Custodial Torture Bill was reintroduced in Parliament in 2023 and again in 2024. India has still not ratified the UN Convention Against Torture despite acceding to it in 1997. 9 death penalties is justice for 2 families. A systemic law would be justice for every family that came before and every one that may come after. That law still does not exist. Now watch what happens when we take this same crime to 10 countries and see 10 completely different answers emerge. In the United States, 18 U.S.C. Section 242, Deprivation of Rights under Color of Law, targets police-inflicted harm directly. Combined with state murder statutes, penalties reach life imprisonment or the death penalty. In the United Kingdom, police face prosecution under the Offences Against the Person Act 1861, the Common Law Offence of Misconduct in Public Office, and the Corporate Manslaughter Act. There is no single statute for custodial murder, maximum life imprisonment. In Germany, StGB Section 340, Körperverletzung im Amt, criminalizes bodily harm by a public official. When death results, Section 212, intentional manslaughter, applies. Combined, the maximum is life imprisonment. In Saudi Arabia, Sharia applies qisas, equal retribution. The victim's family can demand execution. A uniform provides no immunity, none. In China, Article 247 of the criminal law specifically targets torture to extract confessions. And if death results, Article 232, intentional homicide, carries the death penalty. But here is where the case takes a completely different turn. In Japan, Article 195 of the Penal Code criminalizes abuse of official duty, up to 7 years. Death elevates the charge to Article 199, murder, with life or death as the maximum. In Norway, Straffeloven Section 275, aggravated murder, carries a maximum of 21 years. No exceptions for rank or uniform. Norway caps all sentences here. In the UAE, Article 339 of the Federal Penal Code criminalizes torture by public officials. Combined with Article 332 for murder, the death penalty is available under both law and Sharia. In Australia, common law murder applies across all states. Police convicted of custodial murder face life imprisonment with non-parole periods of 25 to 30 years. In Brazil, Law 9455 of 1997, the Lei de Tortura, specifically punishes torture resulting in death. The constitutional cap on imprisonment sits at 40 years. Let me rank these, harshest to most lenient, for the exact same crime. Ranked first, Saudi Arabia. Public execution under qisas. The victim's family holds direct power over the sentence. Ranked second, UAE. Death penalty under Federal Code and Sharia. Dual track severity. Ranked third, China. Article 232, intentional homicide, carries the death penalty, consistently applied. Ranked fourth, USA. Life or death row, state dependent. Federal Section 242 ensures no uniform protects a killer. Ranked fifth, India. Death penalty confirmed. Rarest of rare doctrine applied. 6 years from crime to sentence. Ranked 6th, UK. Whole life tariff. No parole ever. No death penalty but imprisonment without end. Ranked 7th, Germany. Life imprisonment, 15-year minimum. Preventive detention can extend beyond the sentence. Ranked 8th, Australia. Life imprisonment, non-parole periods of 25 to 30 years, state-specific. Ranked 9th, Brazil. Constitutional cap of 40 years. The torture law adds specific provisions, but the ceiling holds firm. Ranked 10th, Norway. 21-year maximum, no exceptions, no death penalty. Most lenient but most predictable. Norway caps this at 21 years. Saudi Arabia would execute publicly. India sentenced 9 officers to death 6 years after 2 men were killed for being open 15 minutes past curfew. My verdict? India's sentence is justified. These 9 men planned, assaulted, covered up, and killed. The rarest of rare doctrine exists precisely for this. But justice that takes 6 years while no systemic prevention law exists is incomplete justice. The most dangerous gap here is not in punishment, it is in prevention. India punishes after the death. Norway works to prevent before it. Both exist for a reason. Neither alone is sufficient. Which system felt most just to you? Tell us in the comments. I read every single one. If you made it here, thank you. Most people don't. You stayed and that means something. One action, 10 countries. 10 completely different answers. That is not just law, that is a mirror held up to what each society truly values. Which country's response felt most just to you? Drop your verdict below. I read every single one. Next week, the O.J. Simpson case, 1994, the most watched criminal trial in history. The law's response to this one will genuinely surprise you. The link is right there. Same action, different world. Your verdict. This is Constitution Compass. Thank you for watching.